Okay, we are now live. I don't expect anybody is going to be logging into this because this is the first video we've done in a while. So first, let me tell you why. I have been offline. I was hospitalized not too long ago with some, and you can't see my hand, of course. So I went down with some chest pains, went to the hospital. I had chest pains. I couldn't breathe, really fatigued. And they admitted me and ran all kinds of tests. So I have not been publishing for a little while. Now the tests are fine. There's no problem with the ticker. My heart's fine. My blood pressure is fine. They put me on some medication. After running tests for several days, they came back and they said, "Oh, by the way, did you know you're diabetic?" I'm like, "No." So I dealt with that. So now we're back. I'm back in the office. Back to work full time again, and got a crushing load to catch up on. But right now, and the reason we're talking about this and we're actually live instead of a pre-recorded one is because A, I'm in my office, I'm not in the car, and B, the Court of Appeals yesterday issued a decision. It was appeal from the Circuit Court of Cole County regarding the release of information from the applications and data from the medical marijuana license applicants. The DHSS had appealed the Circuit Court's judgment quashing its preliminary writ of prohibition and denying the department's petition for a permanent writ of prohibition. The department contended that they cannot be compelled to disclose data submitted by medical marijuana license applicants because the Missouri Constitution requires it keep that information confidential. The court had affirmed the quashing of the information, quashing of the preliminary writ of prohibition, and denying the permanent writ. Now, let's talk a little bit about the facts and the history here. Okay, first, Article 14 of the Missouri Constitution was approved in November of 2018 through the Initiative Petition Amendment 2. Most of you are aware of that. It was pretty important. The Article 14 authorizes and regulates medical marijuana, and I'm reading from the opinion right now as well. Not every word, because that would be ridiculous. Now, the department is directed to administer a state medical marijuana program, including granting or denying state licenses for cultivation, manufacture, dispensing, sale, testing, tracking, and transportation of medical marijuana as provided by law. Article 14, Section 1.31a. The article provides the department to make available to the public license application forms to operate medical marijuana cultivation facilities, medical marijuana testing facilities, medical marijuana dispensary facilities, medical marijuana infused products manufacturing facilities. And the article allows the department to restrict the aggregate number of licenses granted in each category. To evaluate the license applicants, 19 CSR 30-95.025, paragraph 4, directs the department to determine whether applicants meet minimum standards described in the regulation. Now, when more qualified applicants applied and there are available licenses in a facility category, both regulation and article provide for the department to use a system of numerically scoring 10 additional evaluation criteria to rank the applications in such license category against each other. That's 19 CSR 30-95.025, paragraph 4. Article 14, section 1.31H. In further discussing how numerical scoring evaluation is conducted, the regulation reiterates that each type of facility application will be scored and ranked against other applications of the same type. Then an applicant who's denied can appeal to the Administrative Hearing Commission. And as we know, there are more than 800 appeals to the Administrative Hearing Commission. And after exhaustion of administrative review, the denial is subject to judicial review. Now, Kings Garden Midwest LLC, Kings Garden applied for 2 medical marijuana cultivation facility licenses. The department denied both applications. Kings Garden appealed denials to the Administrative Hearing Commission. One of the allegations in Kings Garden's appeal was that the applications were subjected to an arbitrary and capricious scoring process. This is something we have talked about extensively. The scoring process is fraught with problems and probably more than a little corruption. In that process, other applicants received different scores for answers that were the same or substantially the same as the answers that Kings Garden submitted. To prove the claim, Kings Garden requested discovery that the department provide complete and unredacted copies of successful cultivation license applications. The department objected to the request, claiming that disclosure violated the constitutional mandate to maintain confidentiality of information. Kings Garden filed a motion to compel and agreed to limit its request to only those questions on successful applications for which Kings Garden did not receive the full 10-point score. The Administrative Hearing Commissioner, Renee Slusher, granted the motion to compel and ordered the department to produce substantially all the documents that Kings Garden requested. Commissioner Slusher gave the department the option to redact the applicant's identifying information. She also entered a protective order covering the produced documents, which is why we don't have them publicly. It'd be nice if we could show you what the applications were, but the protective order prevents Kings Garden from distributing, and we don't have that to share. Then the department filed a petition for writ of prohibition, asking the circuit court to bar enforcement of Commissioner Slusher's order, compelling it to produce the information. The circuit court entered a preliminary order in prohibition, ordering Commissioner Slusher to refrain from all action until further order. After briefing and argument, the court quashed the preliminary writ and denied the department's petition for a permanent writ. The court stayed the judgment for 40 days or final resolution to allow for a timely appeal, and the department appealed. So what exactly were they looking at when they evaluated this? Well, the sole point on appeal from the department was that the circuit court erred in quashing the preliminary writ, denying the permanent writ of prohibition because it claimed Commissioner Slusher acted outside her authority by compelling disclosure of requested applicant data to Kings Garden. The department is claiming that it can't be compelled to disclose data that's submitted by the medical marijuana license applicants because the Constitution required to maintain confidentiality of that information. So what that means is the court is going to review the law, and the court will review the law de novo, which means they're going to look at it independently, regardless of what happened in the circuit court. They're going to look at it as if a fresh look. So the constitutional provision at issue is Article 14, Section 1.3, Paragraph 5. Let me just read that to you. The department shall maintain confidentiality of reports or other information obtained from an applicant or licensee containing any individualized data, information, or records related to the licensee or its operation, including sales information, financial records, tax returns, credit reports, cultivation information, testing results, and security information and plans, or revealing any patient information or any other records are exempt from public inspection pursuant to state or federal law. Now, there is a maxim of law, and this goes all the way back to Old England before we even became a nation. The inclusion of one is the exclusion of all others. So if I say I want you to produce tax returns, credit card receipts, and deposit slips, if I say I want you to produce your financial information, including tax returns, credit card receipts, and deposit slips, those three are the only financial information you're going to have to produce because those are the only things in that list of included information. Now, in this case, we have the constitutional provision which says any individualized data, information, records related to the licensee or its operation, including sales information, financial records, tax returns, credit reports, cultivation information, testing results, and security information and plans, or patient information. So the actual application is not included in that list. So it would not be a private information. Now, the department argued that the intent of the voters in enacting this provision was to mandate it keep all information filed in medical marijuana license applications strictly confidential and immune from disclosure. Now, I got to tell you, I don't think the public believed that at all. The public really had no intent to keep the application process that was fraught with corruption and other issues confidential. They really had no intent to protect MOCAN and the people that were playing games and shenanigans here. So to support its argument, the department relied upon, and I'm not going to get into the case law. None of you care probably. If you do, go read the opinion news available on the Western District Court of Appeals website. So they examined other cases and they looked at the Tucker case and whether or not stated exceptions, general rule of confidentiality applied. In determining no exception applied to allow disclosure of information, that court stated statutory mandated confidentiality is not overcome by demonstrating relevance or in the absence of traditional evidentiary privilege. Now, a crucial distinction between that Tucker case and this case at bar, and you didn't see me just tap the case on my desk, but I did, is that while none of the exceptions confidentiality set forth in 210.150 applied to allow disclosure of statutorily mandated confidential information in a juvenile case, Article 14, Section 1.35 expressly allows constitutionally mandated confidential information to be used for a purpose authorized by this section. In the second sentence, such reports or other information may only be used for a purpose authorized by this section. In that sentence, this section refers to Section 1.3, subsection 23 of Section 1.3, and it gives denied license applicants the right to appeal the government's denial to the Administrative Hearing Commission, and following that to seek judicial review. Because an appeal to the HC in the courts is authorized, the plain language allows confidential information to be used for the purpose of an appeal of a license denial. This really is common sense. Further, Section 1.35 does not limit the use of information in appeal of a license denial. The information is subject to discovery as provided in 1 CSR 15-3.420, the regulation governing discovery and contested cases before the Administrative Hearing Commission. In the appeal, Kings Garden was seeking to discover information from successful applications to prove that its applications were subjected to an arbitrary and capricious scoring process in which successful applicants received different scores for answers that were the same or substantially the same as the answers Kings Garden provided. I got to tell you, before I go on, this is an important point because this is going to change every appeal in process. The arbitrary and capricious manner argument is going to continue to be brought forth by all of the appellants. Now, how that's going to be resolved, man, I don't know. Is the court going to order licenses to be issued to all 700 people? If so, doesn't that create an arbitrary and capricious situation where, other license applicants can't get a license because there are 700 other licensees? I don't know how that's going to work out. The courts are going to have to figure that one out, and it's going to be interesting to see how they do. So the department's regulations expressly direct the department to score and rank qualified applications against each other to decide which licenses to grant or deny. Because applications are not solely judged on their own merits, but are ranked competitively, the only way to determine whether the department denied Kings Garden's applications in an arbitrary and capricious manner is to compare Kings Garden application against information from the successful applicants. To interpret the Section 1.35, paragraph 5, as not allowing discovery of information from the successful applications would lead to an unreasonable and absurd result that unsuccessful applicants pursuing an appeal, and in turn, the Administrative Hearing Commission and the courts would be denied access to information that is an integral part of the department's decision to deny their application. Without that information, there can be no meaningful review of the decision. It's just not possible. So the courts are going to have to avoid that construction of the Missouri Constitution that are unreasonable or lead to absurd results. This is longstanding law in Missouri. I can give you the case, but again, you don't care. It's in the judgment. So, because the plain language of 1.3 paragraph 5 allows confidential information to be used for the purposes of an appeal of the department's decision to deny a license, Commissioner Slusher didn't err in granting Kingsguard a motion to compel and ordering production of certain confidential information pursuant to a protective order. Now, consequently, the circuit court didn't err in denying the department's petition for a writ. That's denied. The judgment is affirmed. Now, there are some footnotes. So the department doesn't challenge the scope of the order and the motion to compel or the scope of the protective order. I have to tell you, courts of appeal do not typically render judgments on things that are not before them. Okay. It was not before the court of appeal whether or not a protective order was even appropriate. So they're not ruling on that. Okay. They're not ordering that you have to have a protective order for this information going forward. That is not before the court. They're not ruling on that point. So what is probably going to be the result of that is that there will be protective orders, and this information will be available to the law firms that are handling the appeals and requesting this information. But they will not be allowed to share it. Does that mean that they won't be allowed, that they're not going to know it and use it in future license applications? They sure as shit will. So the attorneys that are involved in these suits are going to be hot commodities for other firms. You'll see that their value will be up a little bit, and that's good. They should. So what this means is that the license applicants are going to get the information needed to present their cases. That is bad news for the Department of Health and Senior Services. DHSS has a problem. They have a big problem. The governor has a problem. He's vowed to spend veterans' money until it's out. Fighting this, it's stupid, but that's where we're at. Now, it is a good day for transparency. It is a good day for Missourians. This came out yesterday. I will see if I can put a link to this in the description. Hopefully I can. But so anyway, thanks for watching. I'm going to end the stream now. I don't see any questions. I see some people on the stream. That's cool. If you have questions, post them. We'll address them before I go. Barring that, I'm going to ask you to like, subscribe, and we will see you again here in the near future. Seeing no questions? All right. Thanks for watching, and we will see you all again soon.